Good afternoon, everyone. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. Today is July 20th, 2023, Thursday at 12:33 p.m. Washington, D.C., New York time, and we are on our live stream, weekly live stream, where I discuss some immigration topics and then answer all of the questions from our audience members. For everyone who views this live, thank you very much for joining. Please like this video and subscribe to our channel. If you have any questions, please post it in the chat section. I will do my best to answer all of the questions. And if you are viewing this after the live stream, you can post your questions in the comment section, and I'll do my best to also answer those questions as well. If you have any friends, relatives who have immigration questions, who are asking you maybe the immigration questions, please let them know that immigration attorney Ismail Shahtakhtinski provides these answers. This live stream answers all of the questions on Thursdays, every Thursday at 12:30 p.m. Washington, D.C., New York time, which is also known as Eastern Standard Time in the United States. Last week, I had to miss the live stream, so it's been 2 weeks, but we will resume this weekly live stream and continue doing it as much as possible. So in this video, I want to talk to you about moving inside the United States while you have your asylum case pending, or for that matter, any immigration case pending with the USCIS. I'm sorry, just 1 second. It seems like there is some technical issue with the live stream on Facebook. If I may, I will just take a photograph of this and notify my admin. Okay, very good. So basically, the topic that I will discuss today, before answering all of the questions from audience, is movement inside the United States. If you move from one state to another while your asylum case is pending, whether it's an immigration court or with the asylum office, what will happen with your case? What are the strategic decisions you need to make if you move? Should you file a motion to change venue? When you should notify the immigration services, USCIS, and when you should notify the court, and whether you should request to move your case from one state or another, or will your case automatically move from one asylum office to another? So you entered the United States as asylum applicant, let's say through CBP-1 process, and you indicated a sponsor, somebody who will provide you a place to stay and who will support you throughout the process as much as needed. So one of the frequently asked questions is, whether you can move and live somewhere else. Do you have to live with the sponsor? The answer is no. So sponsor is an individual who guarantees, provides, to provide support to you. But if you can support yourself, if you have sufficient financial ability to rent a space for yourself, or you find a job in the US and you move to another state, good for you. You can do so. You're not stuck with your sponsor. You're not stuck in the state where you initially entered into the United States, or you're not stuck with the locality where you initially lived in the US. So you can live anywhere you want. If you find a good job, you can move across the country. You can move to any state of you can travel also, not just move, but also travel for vacation or anything you want to. I'm often asked about whether you can travel to Hawaii, and for those who don't know, Hawaii is one of the states of the United States, one of the 50 states. And just 1 second, I'm sorry. Yeah, so it's one of the states, and you can travel. Anybody who is inside the United States, you can travel to Hawaii, just like you would travel to New Jersey, to Florida, California, or whatever else you want. Now, if you relocate from jurisdiction of one immigration court to another jurisdiction of another immigration court, typically that's if you move from one state to another. But sometimes there are multiple immigration courts in one state, just like here, or there may be, for example, in Virginia, or there may be an immigration court that is regional, it covers several states. So that's why I'm using the word moving from jurisdiction of one immigration court to another rather than from state to state. So if you move from jurisdiction, what you should do, you have to by law notify the immigration court and the assistant chief counsel, which is the representative of the government in immigration court case, about your new address within 10 days. So that's the law, that's the requirement. And the same applies if you move while your asylum case is pending affirmatively with USCIS. Now, if you move while your case is in immigration court, you notify them of the change of address. That's very important. You should do it as soon as possible. Now, does that mean your case will automatically move from this court to another? The answer is no. It will not automatically move. So what you can do is you can request the change of venue. Now, the decision whether you should request the change of venue and if you should, when you should do it, is very intricate and delicate decision to make, because there are many factors to consider. What is the is the new immigration court, which is going to be by your new address, having jurisdiction over your new address, is that court preferred over the current immigration court or the immigration judge, specific immigration judge? Does your attorney have experience or success or preference over the current immigration judge or not? So which court has cases processed faster? If you want your case to be processed faster, if you want your individual hearing to be held earlier. So all of those decisions need to be considered. Additional factor to consider is your employment authorization document. So if you applied for asylum while your case is in immigration, while in the middle proceedings in immigration court, the clock for your EAD, employment authorization document, which is 150 days, has started from the date you filed for asylum. Now, if you move to another state and requested to change your venue, that clock stops until the new court takes up your case, schedules a hearing, and you actually have that new hearing, which is typically the master hearing. So, and then even there is glitch. Sometimes the administrator of the new court forgets to press the button to restart your clock. So your clock gets stuck. You're not eligible for employment authorization, and that can last for a long time. So all of these things need to be taken into account if you're moving from one state to another. In immigration court, in asylum office, you don't get a choice. You basically, if you move from one jurisdiction of one asylum office to another asylum office, again, could be from one state to another state, then asylum office, you have to first notify the USCIS. That's given, you must do it. And once you do it, they will automatically send your case to the new asylum office having the jurisdiction over your address, your new address. And that's not your choice. You don't have to file a motion to change venue or anything. All you do is just notify them of the new address, and they will automatically do it. That's how USCIS handles versus the Department of Justice, immigration courts when you move. Now, similarly here as well with asylum officers, you should consider whether you should move or not, or when you should move, and again notify them of the move to the new jurisdiction, new location, new state. Now, sometimes I hear questions, or sometimes I see clients who moved but they didn't notify the immigration court or asylum office. That's very bad. Or they use their friends or relatives' address and pretend to be still living there. For example, somebody who lived in New York asylum office or New York immigration courts are relatively more liberal and loyal, have better approval ratings versus, for example, Texas, right? So somebody moves from New York to Texas because of job opportunities, and but because they don't want to give up their jurisdiction in New York, they don't notify of the change of address. They keep some address, which is basically a dummy address. Nobody lives there, or it could be a friend or relative and so on. Don't do it, because one way or another, it will be revealed. And once it's revealed, it will be most likely will be held against you. And the reason I say most likely is because sometimes, some immigration judge or officer or the chief counsel may not notice this or may not pay attention to this, but a lot of times they do. Somebody who does their job diligently, they do. And what I mean by that is, you're basically already coming across as somebody who is misrepresenting information, because you're telling this immigration court that you live in New York, but actually you live in Texas, and all you're doing is physically you're not living there, you're just using your friends or relatives address or just some dummy address so that you hold on to the jurisdiction of New York immigration court or asylum office. Don't do it, because it's federal government on the other side. They have easy ways of finding out where you actually live versus where you indicate you live. And sometimes people say, how do they do it? Well, you can use your imagination. When you live somewhere, let's say you're in Texas, right? You're employed probably, so you have an employer who's paying you your paychecks, and they're using your address where they're mailing it. They're mailing it your pay stubs or whatever that might be. You have bank account. Probably you're getting some kind of, you have a credit card that you use, or you have your driver's license. You may be stopped by a traffic police. You leave traces in the places that you live. You've probably seen it in the movies, how they find locations of individuals by, tracing things that they have done. So we're talking about the Department of Homeland Security or Department of Justice, who have unlimited resources to be able to find out whether you are lying about living in New York or you actually live there. So don't fall into those traps. Don't listen to the advice of friends or acquaintances or paralegals who tell you, oh, just use your friend's address, don't worry about it. Nobody's going to know that you're actually in Texas. They'll think you're still in New York. So don't do it. It's easily found, and once it's found, even if you have true asylum basis for your asylum case, you have a good asylum case, you will come across as somebody who's lying because you just lied even before the hearing began. They found out that you lied about your address. So why they should believe what you say now, whether it's immigration officer or immigration judge. So these are the things I wanted to tell you about. If you move inside the U.S., after you enter the U.S., you can freely do so. If you do, there are important decisions to make, whether to change venue or not. And there are important decisions to make where to move, so that you don't end up in a jurisdiction with a highly negative rate of approvals, not negative, but low rate of approvals, or negative attitude towards the types of cases you're handling. That's the reality in the United States. Unfortunately, we have, as many other things, we have this division. There's anti-immigrant sentiment in the conservative states, among the conservative party, in the Republican Party, and there is pro-immigrant sentiment in the Democratic Party, and among liberals. So sometimes clients just ask me randomly, which state is better, which state is worse to be in. I say statistically, if you take the map of the United States election in 2020, Trump versus Biden, you look at the red states, people that voted for Trump, you're more likely, statistically, not all of them, but you're more likely to have anti-immigrant sentiment. People that are more skeptical towards asylum applicants or individuals who entered the United States through the border, even if lawfully, and applied for asylum, versus somebody who's coming from the blue state, from a liberal state, democratic state, where they have more, sympathy towards immigrants. So just statistically, that's just the math, so you have more chances of having a judge or a government attorney or officer from the population of that blue state who's going to sympathize towards your case. But again, you shouldn't put all your bets on just the location or the court or the judge. Things can change frequently. All right, so I will answer all of the questions. For everybody who joined now, please post your questions if you have any questions in the chat section. If you like this live stream, if you enjoy getting answers to your questions, or please press like, please subscribe to our channel. In our channel, we post important videos about the ways to apply for asylum, how to do things, how to procedures, lots of information about how to prepare your application. And it doesn't necessarily refer to asylum. It could be anything else. We handle, family reunification cases, investment-based visas, talent-based visas, work visas, business immigration, student statuses, and so on and so forth, and asylum and removal proceedings cases. So please subscribe to our channel. Please like this video if you like this format. If you don't like it, this is freedom of speech. We are in the United States, and you can freely post your criticism, post it here. Tell me. I promise to take into account, and if anything needs to be adjusted so you invite your friends or you enjoy these live streams more, I will be happy to do so. So please don't be shy to post in the chat section or in the comments of this video any comments you have, whether it's positive or negative or it's criticism. So let me know. Maybe I talk too low, maybe I speak too fast, maybe I should do it in a different format. So feel free to criticize, tell me what you think I should be doing differently. All right, again, so my name is Ismail Shahtakhtinski, immigration attorney, principal attorney at IS Law Firm, and I have over 16 years of experience. I'm a member of American Immigration Lawyers Association, and I am answering all of the questions from our audience. If you have any questions, please post it in the chat section. So I'll start with the answers to the questions from audience, and then I will go on to answer questions from social media accounts that were posted and from our admin. Okay. Ahsan Rasul is saying, hello, sir. Hope you will be fine. Thank you, Mr. Rasul. I hope so too. I hope you're fine too. I believe, Ahsan, you're saying because I missed last week's live stream. Yes, I was on a family vacation, and I was in a moment where I was planning to have the live stream, but it was, part of the day where it was just impossible virtually. It would have been through without Wi-Fi, and it would have been very blurry and not so pleasant to follow. So that's why, unfortunately, I had to skip last week's live stream. All right, Emir is asking, can African people use the CBP1 app to enter the US, or it's exclusively for Latinos? No, there is no such a thing as exclusively for Latinos. Anybody can use CBP1 app to enter the United States, as long as you have basis for asylum, as long as you have identification documents. So anybody can use CBP1 to enter the United States in orderly manner to apply for asylum. You will be processed. You will not be detained. More than 98% of the cases, there is no detention. They ask you very few questions, but they'll call you to immigration court where you have to present your case and demonstrate that you deserve asylum. So that's the point of CBP1, but it's not gonna stay forever. Telling everybody all the time, this program is not going to stay forever, and if it does stay, it's not going to be in the same format it is today. It's actually already getting worse. So there are groups and organizations that are taking advantage. They're registering multiple individuals. As you know, you can download that app only while on the territory of Mexico. So there are people that I know that are going to Mexico, using it to download the app in territory of Mexico and register individuals who are not yet there. So by the time they arrive, they will have their interview. So there are lots of schemes and tricks people are trying to do, or these groups, organizations, individuals, crooks are trying to do to circumvent the regular wait in line procedure. So this is not going to last forever. If you have basis for asylum, if you have fear of persecution in your country, you've been thinking about coming to the US and applying for asylum, you don't have a visa, come to Mexico, use the CBP1 app, that's perfectly legal, and the United States Customs and Border Patrol agent will schedule an appointment, will ask you questions, and in the orderly manner, without your detention, will allow you to enter the US and come to immigration court and prove that you deserve asylum. So do it as soon as possible if you have basis for it. All right, for anybody who joined, please post your questions in the chat section. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. Thank you for joining us. This is our weekly live stream where I briefly discuss an immigration topic and then answer all of the questions of the audience. A lot of times we have individuals who are looking for free consultations. We direct them here so that they can post their question and get these answers free of charge. If you know anybody, you have a friend, a relative who's asking you questions, or you know who needs legal service or legal help, and they may have these general questions that they want to ask for free of charge rather than scheduling a consultation with an attorney, please refer them here as well. And if you have any questions, please post it here. If you like the format of this video, if you like what I'm doing by these weekly live streams answering these questions, please press like. I'll greatly appreciate this, and subscribe to our channel. If you don't like it, again, please also post your comment, your criticism. I'll be happy to review it, and I appreciate any kind of comment or criticism. So next question is Hassan is asking, sir, my question is that our family asylum was approved in 1994, which was petitioned by my father. But my father has died these days and our case is still in USCIS. My father has traveler documents. Okay, so if your family's asylum was approved in 1994, so why is your case still in the USCIS? 1994, I mean, that's what, almost 30 years now. But why your case is in the USCIS? It doesn't make sense. Now, you're saying that your father filed a petition for you and then he died. What kind of petition? Was it asylee family petition? That's too late to file. I mean, it shouldn't have been lasting so long. And if he filed a family reunification petition, alien relative petition, which is the form I-130, then, you know, if he died, sorry to hear that, but if he died, there is a possibility to be able to keep that still alive, his petition, so that you and your family can still qualify. In short, Hassan, I'll have to tell you that you have to consult with an immigration attorney one-on-one, individually. This is very detailed and fact-specific case you have, and you know, you're not going to get a quick answer. And a quick answer, I'm afraid, that you may receive in the forums or live streams or Q&A sections like this is not going to, you know, it has a very high chance of being wrong answer because we don't know all of the details of your case. As I told you, you know, there are many questions that you need, the attorney needs to be answered before being able to answer your question. Okay, Melissa is asking, can I maintain two status here in the US, like for example, F1, and also use EAD card with pending asylum case? Yes, the answer is you can maintain your F1 and use your EAD card with pending asylum case. Now there is anecdotal, well, not anecdotal, there's an argument, but some of my colleagues, immigration attorneys in the Immigration Lawyers Association, saying that, well, if you file for asylum, or let's say if you get a TPS and use EAD card, does that, because it's not compatible with the intent of F1 status, does that mean that you lost F1 status? My answer is no. There is no specific guidance or law or, you know, regulation about this issue. But generally, you know, I've had a lot of clients, or I can tell you based on practice, that the USCIS or the DHS never created any issues with that. You know, I've had many asylum F1 student clients who had pending asylum case and had EAD based on the pending asylum case that they have used, and they still maintained their F1 status. How do we know? Is because once they were eligible for change of status, or let's say they found an employer who was willing to sponsor for H1, or they had qualified for permanent residency through employment-based EB3, we were able to change their status from F1 with no questions, no issues about the fact that they worked using the asylum EAD. Because again, the argument there is the counter argument to those colleagues who are saying, oh, you can theoretically lose your F1 status, is that EAD is based on the pending, it entitles you to be employed based on your pending asylum case, and it shouldn't interfere with F1 because you're not using EAD in violation of F1. It's just basically ancillary on top of your F1 status. Again, similar to TPS status, giving you a chance to work in the United States on top of your ability to remain in the US and maintain your F1 status. Melissa's next question is, if somebody is resident in another state and for like 4 months he or she attends school in another state, how will consider that asylum case? Didn't understand the question. Somebody's residence in and for like 4 months, you're in another state. How will that consider that asylum? The question is not clear, Melissa. If I stay in Maryland and I go to school in Michigan State, where can I file for asylum? Oh, okay. So going to school has no effect on where you apply. You apply for asylum, you indicate your address of where you live. Now there is no such an there is no such a notion as where to apply for asylum. You're not actually applying in a location. All asylum cases are filed online, and now they're filed online. You can file on paper, but they're filed in service centers, whether you live in Michigan, Maryland, or so on. So you're not applying where. There is no location for specifically Marylanders to apply or for Michiganers to apply in Michigan. All of the applications are filed in the same. So the question I guess you're asking is, which address should I indicate when I apply for asylum? So when you apply for asylum, not just asylum, any kind of immigration forms, the forms are very specific. It tells you, indicate your physical address. Now, the fact that you're going to school in Michigan has no bearing on your physical address, right? Because it didn't say where you go to school or indicate the address where you go. It says, what is your physical address? So rather than bending this or putting other facts into the play that you're going to school in Michigan and so on, it's a very simple question. What is your physical address? So you indicate your physical address. If you sleep and wake up at a certain address, indicate that address. Now, if you live in Michigan, if you go to school there and because of school you are physically there, you wake up and sleep in Michigan, you have your bank statements, you have your address, this is the physical location where you daily spend your time, then indicate that. Now, in rare circumstances, there may be somebody has 50-50 address. Somebody literally spends 50% of time in one state, 50% time of another state. That's a rare circumstances when you can make the call and say, I'm resident of Virginia, but I have a farm in West Virginia. I'm spending half of my time there, so I can also count myself that I live there physically and, here both places. So, it's up to you. Again, for anybody who joined, thank you so much for joining. And if you have any questions, you can post your questions in the chat section. I will be happy to answer. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. This is our weekly stream. So I will answer some of the questions that are posted by admin. All of the questions that are posted by admin, they're from our social media accounts. If you have any questions, please post in the chat section. Or if you have any comments, anything you want to say, please post, please comment, and any questions I will be happy to answer. All right, so EK Fedorova asking, Ismail, how often prosecutors want to discuss about case prior to the hearing, how to reach them successfully and narrow the questions? Well, depends on the prosecutor. So the board prosecutor, for anybody who doesn't know, this applies to the government attorney, which are known as assistant chief counsel in immigration courts. So they play the role of the prosecutor, but they're not exactly prosecutors, but they represent the government in immigration court. So there is a judge, there is a government attorney, and there is you and your attorney. So your lawyer and you, the government lawyer, and the judge. So that's the government lawyer is prosecutors, so to speak. They depends on them. Some of them are very diligent. They prepare before the hearings. Way before the hearing. Sometimes they reach out to me. Sometimes I reach out to them if there are things that I want to discuss and narrow down beforehand. So it's case by case, really. Sometimes I know the chief counsel that is handling this case, and I know them because I've worked with them before. And we talk and just honestly share opinions and narrow down the issues, narrow questions. Sometimes it's very successful. Sometimes I have the assistant chief counsel telling me that they'll agree to asylum. Then woohoo, we won, everybody's happy. Sometimes they tell me they will agree if we demonstrate this. And Sometimes we agree that we want to just go to cross-examination. I don't have to question my client. They'll say that, okay, everything in the affidavit we accept as it is. We don't doubt the credibility, but I will ask questions. So the government attorney will just begin with the hearing, at the hearing, will begin, begin with asking questions. Judges love that too, because they don't want to waste the time, sometimes days of hearings for immigration court. And this happens now lately a lot, that we have individual hearings that last several days, where the immigration court has to reschedule and continue and so on. It's just things got really bureaucratic and difficult. And some government attorneys are, because of the loosened, procedures, immigration laws, some of the government attorneys that have this, I don't know, I don't want to label anybody, but they have this, dislike of easing these immigration procedures. A lot of them don't like the CBP1 process, or just have the personal, sentiment, anti-immigrant sentiment. They are putting a lot of obstacles. They're trying to make it as hard as possible, despite the fact that the, Department of Homeland Security, head of the DHS and head of ICE, they issued the prosecutorial discretion, kind of explaining these government attorneys, that these prosecutors, that their job is not to just do everything they can to cause somebody being deported, but to actually get to the justice, to actually, consider that asylum is a humanitarian form of relief. They're not here to prosecute criminals. They're here to find out if this person deserves help, and there is humanitarian asylum basis, even if by law there are things, causing issues with eligibility for asylum. There are humanitarian asylum basis. The government attorneys can agree, grant asylum by agreement. So there are many different things that they should consider, and not just try to make life of asylum applicants as hard as possible. And unfortunately, on an individual basis, some of the government attorneys are still doing that, whether individually or whether their supervisor is doing that, whether it's specific jurisdiction. I can't tell, but I can tell you is that it's not like it's Biden administration and everybody gets the free ticket to the United States and everybody gets asylum approved. No, that's not the case. And in some cases, it's actually opposite. So next question I have, let's see if audience posted any other questions. All right, okay. So I own a political YouTube channel where I'm criticizing government. Question, how to present my YouTube channel to the judge? Happy Moon is asking. So very good question. Anytime you have first of all, let's talk about YouTube specifically, YouTube channel. So just the YouTube channel itself. So when you have a YouTube channel, you can always print a screenshot or print to PDF the actual, the heading of the channel. If you click on my channel, on our law firm's channel on YouTube, you will see the description of the channel and so on. You will see a bunch of videos with the titles, with the headers, so you can do that. Next, what you can do if you want to provide information about a specific video inside your channel, what you can do is you can get that video transcribed. So there will be a still picture of the video and the transcription of what it says. But you will need somebody who, there are lots of services who do the transcription services, including for immigration courts. They do. So you can hire them, they'll transcribe. Now, if it's in a different language, that there will be a transcriber and interpreter. It may be the same person who transcribes the video and then certifies that I am so-so. I transcribed what was on this video. This is the link I watched, and I transcribed it. And I translated it into English language, and I'm fluent in both languages. And here's my information, contact, blah, blah, blah. So just like any other translated document. So that's the way to use videos. A lot of times we have asylum clients who have not only the videos that they posted or they made, but also the videos about them. Maybe a video of a protest where everybody's being beaten up, and there are things that are being said by the journalist, or something's going on. There is some communication, conversation. So what we do is we get the stills of the photographs and the transcription of what happens. We can actually have a still transcription, like screenshot, transcription, screenshot, and transcription, and translation if needed. So that way, it just that's the only way you can actually use. Unfortunately, immigration courts, I still don't see any ability to present any video evidence to the immigration judge. I mean, I don't see anything prohibiting doing that, but I also don't see any way. And I've asked in the past judges and before the hearings, obviously, when we were presenting evidence, can I present something in video recording? And that's what they're telling me is that they want to see the screenshots and the transcription of that, because that's how, unfortunately, there is no record in video format. There is audio record and the transcription that goes to the Board of Immigration Appeals. I think part of it is because if you appeal the case, you cannot send the video to the Board of Immigration Appeals. They will just look at the transcription. It has to be record that is scanned, not video record. So that might be the reason why they don't accept video evidence. All right. So next question, Mary K. Sometime judge is asking. Sometime. Okay, and I thought it was part of the name. Mary K. is asking. Sometimes judge could ask to do direct examination only from prosecutor's side by skipping questions from attorney. Do you think it's worth to do so? Yeah, I just said that, yes, sometimes it happens. That's usually judge. It's not the judge's decision. It's your and your attorney's decision. And I cannot give you just blank answer, it's worth or not. It's case by case. It depends on your case. There may be some important points that you or your attorney want to make. So you don't, to make it as part of the record and as part, as also impression on the judge. So you don't want to skip that. You don't want to just give the government side, only cross-examination without making those points. In some cases, there are no such points. Everything is clear. If they are agreeing, if the government is agreeing to accept your testimony, which you provided in writing, then that might be much better and easier. So it's case by case. There is no, one shoe fits all answer to this question. All right, Udir is asking, is it okay to go to the border Tijuana without CBP1 appointment because a app didn't work? No, it's not okay. I mean, if you go there, you'll probably be detained. It's not like, I'm not saying don't do it. It's your decision. I'm just saying whichever is better option. CBP1 is much better. And also, if you don't use the CBP1 app, you will have a transit ban, which is a new law which says if you're coming through a third country, you have to prove that you couldn't apply for asylum in that third country. It doesn't apply to the case of CBP1. That's exempt. So if you use CBP1, you don't have this transit ban, which creates more obstacles. All right. And Berbir is asking, how long will it take for an asylum interview schedule from the day of application? Can they call me for an interview before I receive EAD? The earliest interview schedule date from your experience. The earliest interview schedule date from my experience was back in the day, I'd say about 10 years ago or so, up to about 10 years ago. So starting from my practice about 16 years ago, the asylum cases were being heard within 3 weeks from the time, 3 to 4 weeks from the time of applying, of filing asylum. And the decisions were consistently issued within 2 weeks of the interview. So within approximately 2 months from the date of filing asylum, we will have fully decided case on consistently on almost every case. Then things went downhill. I don't remember the exact years, but I believe sometime in 2010s, and then it got worse and worse and worse. So that's the earliest interview schedule from my experience. Now, we had a case filed for Afghani citizen about 2 years ago that got scheduled for asylum within 1 month. And then in 2018, it was still Trump administration, they tried to prevent people applying for asylum just to get by because of the backlogs. There were lots of individuals who took advantage of these backlogs and filed frivolous asylum applications so they could get EADs and just get by lawfully present in the US while pending asylum case without really having basis for asylum. And that added significantly to the backlog. So trying to prevent that, in 2018 under Trump administration, they tried to initiate this, to start reviewing the newly filed cases, like in the back in the old days, within 3 weeks and so on. It worked initially. So they were trying to spook those frivolous asylum applicants that if you file for asylum today, we're going to review a case within 3 weeks. And if you don't qualify for asylum, you'll be placed in the removal proceedings. And they even tried to negotiate and agree with the Department of Justice that the immigration judges are going to review those cases faster. And that was part of the chaos they created in immigration courts by trying to do that. And they were promising within 6 months, the immigration judge is going to say yay or nay, and you'll be ordered removed from the US, trying to prevent those frivolous asylum applicants from filing. I think that was a good idea, but it didn't work because they couldn't implement it, because the asylum offices didn't have enough resources, enough budget. The Republicans were, although again, it was idea of the Republican administration, the Republicans in the Congress, as always, were suffocating the budget of the immigration services, and, asylum offices and DHS and immigration courts, because all of those agencies have the word immigration in them, and to impress their, Trumpist basis, they've always been trying to suffocate the budget for those agencies, although they don't understand that this is actually helping to reduce illegal immigration. Just the fact that the name of the agency has the word immigration, it doesn't mean that it's, for immigrants. It's, it could be immigration enforcement. So anyway, I'm not going to go there, but that's what happened. And then it got worse and worse and worse. So it's stopped really working. So nowadays, once in a while, we see a case where interview scheduled within 6 months, but typically they all fall into that backlog, and that will continue probably for years to come. Unfortunately, there is no meaningful, realistic plan to clear it up, unless there is some kind of reform in the Congress. Becomes smart and allocates enough money to clear it up, so that we prevent all these frivolous asylum applications taking advantage of these extensive backlogs, and not cause the real, poor refugees and asylum applicants who really deserve asylum to wait for years because of all these frivolous asylum applications. So, yeah, unfortunately, I don't have a clear answer to this, but hopefully what I explained to you here is, explains what, hopefully what I said gives you some kind of idea of what's going on. You didn't answer my question, or can't you see it? I guess that was the question you're referring to, Birbir. If you have any other question, Birbir, that I didn't answer, you can post it again, and I will do my best to answer. So for anybody who joined, this is our joined just now. This is our weekly live stream where I, immigration attorney and principal immigration attorney at IS Law Firm, I answer all of the questions of our audience. You can post your questions in the chat section. And in the beginning of this video, I also spoke about I spoke about moving inside the U.S. while your case is pending, your asylum case is pending, whether it's affirmatively with the USCIS or whether it's pending with the Department of Justice immigration courts. So the next question I have: what is the difference between immigration attorney and immigration consultant, and who is qualified than other to practice? Who's more qualified than other to practice? Yeah, so immigration attorney is somebody like me, who's licensed immigration attorney, who is able to appear in immigration courts, who has a license identification number from at least one of the states. I'm licensed in Virginia, Maryland, Washington, D.C., and New York. but typically, immigration attorneys are licensed in one state. So they have to have a degree in the United States to be able to pass the bar exam. The minimum is the LLM, which is Masters of Law, and what I have is a Juris Doctor, which is the doctorate degree that you have to be able to pass the bar exam, for example, in Virginia. So these are the immigration attorneys. We can prepare the forms, we can answer questions, we can give legal advice, we can represent clients in immigration courts. Now, immigration consultant, there is no such thing. Officially, there is an accredited representative. That is, it's also an official position. It's somebody who doesn't have the bar license, attorney license, but they go through certification process. They're allowed to provide immigration assistance to some extent, which is pretty much almost the entire extent, except I believe a representation in immigration courts or in front of Board of Immigration Appeals. And then there are individuals that call themselves immigration consultant. These are basically, somebody similar to somebody who doesn't have a medical license, who's giving medical advice, who it's just could be just somebody. Anybody can call themselves immigration consultant. That's not legal. They cannot do it. Any advice, any consultation they give without attorney license. In many states, that's considered as felony. It's a crime, and including in Virginia, I believe it's a felony. So, they're doing it disservice to themselves, disservice to you, because what they do is they may help majority, maybe somebody who's very well informed and very skilled, but if they make a mistake, they're ruining somebody's life, and sometimes they don't care and they cause more damage than help. All right. So then the next question, and I will answer is, and I'll also explain who's paralegal. Paralegal is immigration attorney's assistant, just like there is a doctor, there is a nurse practitioner, and there is a nurse. Similarly, there is an immigration attorney, there is accredited representative, and there is paralegal, somebody who's assisting immigration attorney. They're usually, depending on their experience in some of the procedures, they may know more than the attorneys, and they provide great help, the great assistance with the cases, but they're required to have an attorney who's supervising them, an attorney who's, is the attorney assigned to the case. A paralegal is not able or allowed to handle a case by themselves. They have to have an attorney who's supervising them, but typically a paralegal is somebody who's experienced and who's helping and assisting attorney in many different levels. And some of things they do better than some of the attorneys. But again, doesn't mean that they can provide services without the supervision of the attorney. And doing so is it's a felony in many of the states. All right. Admin is asking, re-entry permit will guarantee that the CBP will not take away your green card? Thank you, sir. Kule Serrano is asking that. So yes, the re-entry permit doesn't guarantee that the CBP will not take away your green card. There is never, don't ever use the word guarantee, right? So in immigration, in relation to immigration procedures, there is never a guarantee in any way. In fact, when you get an advanced parole, you actually get on the advanced parole, it actually says that your entry into the U.S. is not guaranteed. Re-entry permit is not advanced parole. So there is advanced parole, which allows you to travel in and out of the U.S. while your case is pending. That's why it's called advanced parole. You get advanced permission to do so, and you're paroled back into the U.S. in advance. And there is a re-entry permit, which is re-entry permit is for permanent resident who's in the U.S. or at the time of application was planning to travel outside of the U.S. for some reason, could be work, could be any other reasons, and spending time outside of the U.S. for more than 6 months or 1 year, 12 months, and so on. So typically, if you stay more than 12 months outside of the U.S., you will lose your permanent residency unless you can prove that there were extraordinary reasons. So not to lose it, you can apply for re-entry permit ahead of time, get a permission, and you will be allowed to be outside of the U.S. for up to 2 years continuously. You don't have to return to the U.S. in between. You can, but you don't have to. And you're not going to lose your permanent residency based on the fact that you've been absent. Now, that's all it does. It prevents you from losing your permanent residency just by the virtue of spending too much time outside of the US during the validity of that reentry permit. It doesn't address any other issues. If you have a reentry permit, move to another state, another country, and become a permanent resident in that country, then that will presume that you still lost your green card, your permanent residence in the US. Because if you're a permanent resident in another country, how could you be a permanent resident in the US? All right. Kai is saying, hi, Kai. And the answer is, the question is affirmative asylum easier to win than defensive asylum? Kai, it depends. Depends on the on the specifics of the officer, the case, the immigration judge. So defensive asylum in immigration court is, you have, again, it depends. So in immigration court, the main difference is in affirmative asylum, you apply, you have an asylum officer who's not usually they're not legally trained. They're just asylum officers who don't have a legal degree. They're not usually attorneys. And there is no arguments back and forth. It's a little bit stiff process where you have asylum officer that's sometimes they're full of themselves and they ask you questions and they just make a decision. Some of the asylum officers are very flexible, they're very knowledgeable, they're very intelligent, ask you proper questions, or even give you an opportunity to maybe argue or explain things more detailed. And some of the asylum officers are just bullheaded and they just think that they know everything about everything, and they have their own predisposition even before you open your mouth. So, and the same thing can apply with the judge. But the difference is that in immigration court, you have more opportunity to talk to the judge, to make arguments. Not you, primarily your immigration attorney, but you have more opportunity to explain things, to address things, to break things down, and to present your case the way you want. Because in immigration court, in defensive asylum case, in immigration court, it's you and your attorney who write the script of how your case is going to go, how you're going to present it. Are you going to put this witness first? And by the way, that's another difference. In asylum offices, the asylum officers are usually, they're the ones, they believe that they're the ones who control everything. They may say, no, I don't want to call this witness. I don't want to hear your family member, or they want to hear your but in asylum and immigration courts, you get to decide who you're going to call as a witness, expert witness, and so on. So all of that plays a big role. So in some aspects, it's better. In some aspects, it's the other one, maybe better. Emir is asking, when applying on CBP1, they ask us about sponsor in the US, how to deal with that. What if I don't have someone to sponsor me? So again, formally, they do require a sponsor. You do need, I actually had somebody who entered the US without a sponsor, but had significant financial abilities and were able to demonstrate that. But again, it doesn't mean it's a rule. So unfortunately, I don't have the answer to that, but but typically, normally they require a sponsor. So find a sponsor. It can be anybody, your friend, relative, or distant friend, or distant relative of your distant friend, or it could be somebody you may pay money to be able to do that. Again, there's nothing wrong with that. They're not doing it illegally. They're, agreeing to sponsor you. So, guys, I've been now on this live stream for almost an hour. Again, my name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. I'm a member of American Immigration Lawyers Association. I represent clients in all immigration matters, focusing specifically on asylum cases, immigration courts, affirmative and defensive asylum applications. These weekly live streams, which are usually at 12:30 p.m. Washington, D.C., New York time. I answer all the questions from our audience on these live streams. Please subscribe to our channel so that you get notified of these next live streams. And also, please like this video if you like it. If you don't like it, please let us know why you don't like it, and I'll promise to respond to every question, every criticism, and review it and take into account. And if you have any friends or relatives who need immigration help and have immigration questions, refer them to our channel. Let them know that this immigration attorney provides free advice and answers free questions. I mean, technically it's not qualified as attorney-client advice because I don't know everything about your case, but I am answering all of the questions you guys have. But you should consult with individual immigration attorney as much as possible for your specific or individual case. So again, these questions that I'm answering here are general answers based on the extent of the information that I have, but don't take it as a legal advice, as a final legal advice, and don't take action based on that. So thank you so much for joining again, and have a nice rest of the week and weekend. Thank you very much.